Bonjour à tous.
Good afternoon, folks, and welcome to meeting 133 of the House of Commons Standing Committee on Industry and Technology, and I'm delighted to see you again after the summer break. I hope you all had a wonderful summer and you're fighting fit to pick up where we left off at this committee. And before we sink our teeth into things, I'd like to have you familiarise yourselves with the directives when it comes to earpieces and so on and so forth, in order to ensure the health and safety of all, including our interpreters, who may otherwise encounter acoustic incidents.
And the motion adopted by the committee on Tuesday, November 7, 2023, as well as the motion adopted on Wednesday, July 31st, 2024. The committee is meeting today to resume its study on the recent investigation report on SDTC. J'aimerais souhaiter la bienvenue à nos témoins pour la première heure aujourd'hui du bureau du commissaire.
I'd like to welcome our witnesses, the Ethics Commissioner, Mr. Comrade Wittgenstein, who's accompanied by Mr. Michael Aquilino, Legal Counsel, and thank you for being with us today. And without further ado, I'll hand the floor to you, Mr. von Wittgenstein. You have the floor for 5 minutes. Thank you very much.
Thank you, Mr. Chairperson, for inviting me to take the floor today. And I'm accompanied, as you said, by Michael Aquilino, the Legal Counsel at the Commissioner's Office. As Conflict of Interest and Ethics Commissioner, my role is to help elected and appointed public officials manage conflicts of interest, as well as investigate possible violations. We administer the Conflict of Interest Act for appointed officials, like ministers, their staff, heads of Crown corporations, deputy ministers, and members of various boards and tribunals. We also administer the Conflict of Interest Code for members of the House of Commons.
Purposes. One, to help elected and appointed officials recognize and manage their conflict of interest. And two, to facilitate the movement of qualified people in and out of the public service without issue. The committee invited me to discuss the Verschuren report that the office issued in July 24. In fact, we conducted two investigations of two officials with Sustainable Development Canada at the request of MP Michael Barrett. One was Annette Verschuren, former chairperson of STDC. The other was Guy Wimé, the former director of STDC. Madame Verschuren et Monsieur Vinet étaient assujettés à la loi en comptant.
In fact, they were subject to the Act without the obligation for a disclosure, and they came under the Act as public office holders without reporting obligations. They were subject to the Act's general conflict of interest rules, but did not have to give the office the kinds of information you see summarised in our public registry.
Assigns each reporting public office holder an advisor who can focus on their individual need. This opens an ongoing dialogue that lasts for their time in office. In contrast, public office holders like Ms. Schuren and Wimé are not assigned advisors. However, they can always contact the office if they need our advice. In my report, I found that Mrs. Verschuren failed to comply with two sections of the Act, subsection 6.1 on decision-making and section 21 on the duty to recuse. Madame Verschuren avait déclaré un conflit d'intérêt potentiel.
Ms. Verschuren declared a potential conflict of interest to SDTC's Board of Directors regarding companies nominated by or associated with two organisations with which she had close ties. In most cases, she abstained from decisions that benefited these companies, but she did not recuse herself, as the Act required, in any of the cases.
The difference between abstaining and recusing is not always well understood. Recusal is more than simply staying silent during the discussion or refraining from voting. It means stepping away entirely so your mere presence does not influence another participant. Or to put it another way, get out of the room. To reinforce this, last week our office issued an updated information on notice of recusal. Mrs. Verschuren also contravened the Act when she participated in two decisions to give COVID-19 emergency relief payment to all companies funded by SDDC, including one in which she had a private interest. In so doing, She followed incorrect legal advice that there was no need to address her conflict of interest because all companies would be given equal treatment. I found no evidence that Mrs. Meshurin used her position as chair of STDC to try to influence other board members in those two decisions when she moved to motion for the payments. This, after all, was part of her role as a chair. In the other STDC the investigation report, I dismissed allegations that Mr. May had contravened the act by participating in the decision to give COVID-19 emergency relief payment to be funded company, including the one in which he had a private interest. J'ai conclu que son intérêt était négligeable à tel point qu'il
I found that his interest was so insignificant there was no conflict of interest, and I applied the principle of de minimis non curat praeter.
questions.
Thank you very much, Commissioner. And to start the discussion, I'll yield the floor to MP Perkins for 6 minutes.
And welcome back. Commissioner, I'd like to talk a bit about the Auditor General's report, which you said you had reviewed as part of this. And the Auditor General found that Ms. Fischer not only held the conflicts of interest you referred to in your opening statement, but mismanaged and had a conflict in interest in a number of other transactions. Does your report cover that when Ms. Vicherin mishandled conflict when she granted Universal Matter, Inc. a payment of $225,000 on March 9th, 2021?
First of all, mismanagement is not part of my remit. So I'm looking only at conflict of interest. We actually looked at every single decision that Mrs. Verschuren took. My colleague Michael can give you details.
Yeah, so beginning at paragraph 61 of the report and going all the way to about paragraph 74, we've lumped together all of the different instances of votes or decisions that were taken. So in certain instances, Ms. Verschuren had declared conflicts of interest but had abstained instead of recusing. In other instances, she had declared conflicts but voted outright. Another, she failed to declare a conflict and had voted. And then also the COVID relief payments where she relied on internal advice.
So she didn't breach it twice, as your report said. She breached it multiple times based on that. Can you tell me how many times she breached it?
In total, there were 24 instances.
24 times as chair, she breached the Conflict of Interest Act.
Yes.
So, and your report deals with just the NR store and the Mars and the Basharian Vanity Center that she set up and their roles. That's in it. So when you looked at it, did you look at any other governor and council besides Mr. Ouimet? I do have some questions about Mr. Ouimet's in your report, but did you look at any of the other GICs? Because the Auditor General also named considerable number of other GICs who had conflict of interest.
We start an investigation and look when we have reason to believe there's grounds for an investigation or when we're being asked for. In this case, we were specifically asked for by Mr. Ouimet to look after Mrs. Verschuren and Mr. Ouimet, and we did so.
Do you not have the power to investigate anyone you want? You don't have to wait for a parliamentarian to ask. You can, when you are made aware of conflicts of interest in your mandate, can you not go at that? When you see that the Auditor General has named other governor and councils, why didn't you expand your report? 82% of the transactions that the Auditor General looked at, she found directors were in a conflict of interest. That's not a mistake of a legal advice. That's a culture of conflict of interest.
Yeah, but you forget, I can, as you quite rightly saying, self-initiate, but I have to initiate it if I have reasonable grounds to do so. The Auditor General report came after we issued the report on Mrs. Or just shortly before we issued. Was it before or after?
Yeah.
No, who came first?
The Auditor General's report came
right.
first, yeah.
And we came about a month after.
So are you going to initiate, now that you're aware of way more instances of conflict of interest on your own?
What purpose would it serve? My job
Well,
is
I'll tell you what, since you asked me the question.
My answer. I can, if I make it, what can I do? I can expose. That's all I can do. I can't fine, I can't fire.
With respect, Mr. Commissioner, that's your job, is to expose conflicts of interest. And the Auditor General found 82% of the time. You dismissed Mr. Ouimet and you said It was de minimis. It is inappropriate for somebody who's a public office holder to personally benefit. And in the case that you outlined, they personally benefit because that loan or that grant from the board that he was on that he voted for benefits that company. Not only did he do that, Mr. Met, but he actually has numerous other conflicts of interest exposed by the Auditor General. So I ask again, since your report doesn't deal with the Governor and Council's overall and the culture of conflict of interest, will you take a look at all those other instances, including Mr. Emet?
And as I've answered you before, what purpose would it serve? All these persons...
Then what purpose do you have a job if you're saying that you don't have any responsibility whatsoever to look at conflicts of interest?
No, I
Just
do.
because, isn't that what you do? You expose them and let the public and parliamentarians decide what should happen since there is no sanctions. So why is it that you dismissed Mr. Emet when he had Lithium, Nouveau, and Swirltech, all his conflicts where he voted millions and millions of dollars to companies that he had investments in? Your report is inadequate, and you should initiate conflict of interest investigations where Governor and Council have been abusing their position 82% of the time.
Let's start at the beginning. My job is there to expose conflicts of interest. But if I find them and I expose them, then the person has to answer to the public, to the Prime Minister, or to the Speaker of the House, as the case may be. And my job is done basically in exposing it. I can't fine, I can't...
Yes, that's true, but you're not exposing them.
But they have to be in office. When they are no longer in office, what good does it serve to
So
expose?
your excuse is it's okay for a conflict of interest and you don't have to look at abuse of taxpayer dollars as long as they're no longer in office?
Abuse of taxpayer dollars is the Auditor General's job, not mine. Mine is conflict of interest, pure and simple. And there is no conflict if you're no longer in office. You do not have a conflict anymore.
So if I commit a conflict of interest while in office and I don't get caught, it's no longer a conflict of interest?
Of course, it was a conflict of interest. If I wanted to, I can. You are out of office. I start an investigation and say, while you were in office, you had a conflict of interest. End of story.
Thank you very much, Commissioner. I'll now yield the floor to MP Van Bynen.
Thank you, Mr. Chair. Can you hear me? Is my mic on? Yep. Okay. Good. You appeared over the summer for the Public Accounts Committee on the topic of the AG's report on STDC. I'd like to ask you some questions about some of your testimony. For clarity, you found that Mrs. Verschieren was in breach of the Act given that she'd failed to recuse herself while participating in decisions where a conflict of interest existed. Is that correct? And that is the crux of the issue, is it not?
Yes, the Act calls for recusing. It does not have a provision of abstaining at all. However, in a couple of cases when there was, she declared her conflict, and then there was what they call the non-controversial motion at the beginning, the consent agenda. Mm-hmm. And she voted on those because she had already declared that she couldn't do. She should have abstained. She should have actually left the room. The moment she said a conflict of interest, should leave the room and not participate. That's what the Act demands. She didn't. She abstained first, said I haven't, and then she actually voted on, in some cases, in other cases she didn't. What she should have done is leave the room, right? And with the emergency, it's the same thing. She was told on wrongful legal advice, there is no conflict here, so she voted.
Okay. Thank you. I'm having trouble with my earphone. Okay, so by failing to recuse herself, she also breached the STDC's own conflict of interest policy. Is that correct?
Correct.
Okay, and there is no record of her ever leaving the room on any of those votes?
No.
So I'd heard that in earlier conversation that individuals had claimed to have left the room, but it didn't reflect it in the minutes. So is there an obligation on whoever was the chair or whoever was the secretary for that meeting to reflect who was in the room and who wasn't in the room?
Michael, why don't you answer that?
Yeah, so the minutes in certain cases reflected that individuals had left the room, and in certain cases they had not. So one of the, I guess, objectives of our examination was to determine whether or not they had in fact left the room and the instances where they had not. So in certain cases, there was a discrepancy between the minutes and what we had heard from witnesses, but in most cases, the minutes were consistent with what had happened.
Okay, good. So I'm sure that there are people in this room here that you as a commissioner, as an appointment by the Prime Minister, failed on your job by not sufficiently keeping an eye on Mrs. Verschuren throughout her appointment. How do you respond to that?
First of all, she was a public office holder. She's not a reporting public office holder. So all she has to comply with the Act. It is not like reporting public office holder who, when appointed, has to fill out a long, detailed questionnaire, and then we go with the person through it and say whether there are conflicts, whether she has to, and then there's an ongoing dialogue between that person and us, and each year, at the end of the year, we review everything, make sure that things will. A public office holder like Madame Verschuren, etc., has only an obligation to comply with our Act and to comply with the internal regulation, in this case STDC. But there's no ongoing dialogue as she comes to us if she wants to. Otherwise, we don't monitor. We have nothing to do with her. The Act is there, and it's up to her to comply with it.
It's the integrity of the individual.
That's it.
That
correct.
that's the driving issue. Okay, thank you. That's all my questions, Mr. Chair.
Merci beaucoup. Je passerai maintenant la parole à Monsieur Garon.
Mr. Garon, the floor is yours for 6 minutes. I think that the work that we do in this committee, regardless of our political affiliations, is important. I take it seriously, and I think that all parliamentarians here also take that work seriously. And what I find particularly upsetting and disturbing is when witnesses appear before us who don't take our work seriously. And I'm not referring to you, mind that, if that can be of any relief to you, but I read your report, I listened to your testimony, and I'd like to read out 2 quotes from Ms. Verschuren here before this committee where witnesses are supposed to tell the truth. And I quote, "In all cases where I disclosed a perceived conflict of interest, I withdrew from the board meeting and I came back after the decisions were taken and recommendations were issued to the board. The same applied to all board members." And I continue, verbatim quote from this meeting, "When the board recommended that the projects be accepted, I left, other members left, and I waited until I was called back in when the recommendation was issued. I was unaware of, etc., etc., etc." So you can see where I'm going with this. Now, I'd like to come back to the testimony before this committee by that individual. I read your report. I've listened to your testimony. Someone is lying. Someone has lied to the committee. Is it you or is it Ms. Verschuren who's lied? Response. Well, there are 2 sources of evidence. Ms. Verschuren's testimony and the reports, i.e. the agenda of each meeting. Now, my counterparts and colleagues reviewed all of the agendas, and in most cases she did not recuse herself, only in a small number of cases. I don't know whether Ms. Verschuren's memory is failing her, but there's a discrepancy between what she's told us and what we find in the meeting minutes. I understand, sir. Especially when it comes to COVID relief payments, she did not recuse herself. That much we know. Would you like to chime in? Well, yes, I don't want to come to her rescue per se, but what the Commissioner's report has shown is that in most cases where there was funding, seed funding or startup funding, well, indeed, Ms. Verschuren did recuse herself. I'm sorry to cut you off. You know how valuable our time is in committee proceedings like this today. But in your report, you noted that there were 24 violations of the Conflict of Interest Act. You've determined that Ms. Verschuren appeared before the committee, and to her mind, there's been no single violation of the Conflict of Interest Act. Sometimes we lose our memory, sometimes we forget things, but 24 times? That strikes me as systematic before a parliamentary committee where the onus is on you to tell the truth. I'm asking your opinion. This is what's supposed to be a normal state of affairs, can you be mistaken 24 times in an appearance before a committee? Well, I think you need to ask that of Ms. Verschuren herself. All I can tell you is what we've done. We, in fact, interviewed her and we looked at the documents and reviewed them. Question, I'd like to come back to the ministers and the department's role. Now, having listened to the current minister and the previous minister, the rhetoric goes like this. This was public funding, and that organisation was not directly under the aegis of the department. There's a board of directors, and we're not responsible. And when the Auditor General signalled that there was wrongdoing, we froze the funding. That's the kind of rhetoric we're hearing. And yet, it strikes me that when it comes to the legislation itself, the previous minister, i.e. the current government, could have initiated audits and conducted verifications and ensure that that public money was being managed in compliance with the Conflict of Interest Act. Don't you think that that would have been normal? Don't you think that the government's investigation, and not criticising you per se, but don't you think that this investigatory work took far too long to get started? And don't you think that this demonstrates that the department has a number of shortcomings and that it should have launched this investigation? This brings to me an even more straightforward question. Is there perhaps a smoking gun here? Well, you're asking me about the department itself, but it doesn't fall under my remit directly. You're talking about political decisions. And it's the voters that are the judge and jury. Well, let me reformulate my question. You produced a report. The Auditor General did her job, and there were assessments that were undertaken. Now, is it your opinion that the department could have carried out some of these verifications ahead of time? And you could have therefore prevented the misuse of public funds, wrongdoing and misconduct. Well, STDC was founded. There are a number of individuals who were appointed. There was terms of reference that were set out, and I can't think of the word in French. And of course, we wanted to bring on board people with a level of expertise, and that is why we didn't appoint them as public office holders per se. In other words, they had no direct contact with us, no obligation to disclose their financial position. And that was a decision that the government made. You can relitigate that decision, but it amounts to that. Now, why was there no anything further done when it came to the appointments? When there were appointments suggested, I just had to follow the rules. Thank you very much, Mr. Gallon. Mr. Massey, 6 minutes. The floor is yours.
Chair, and I guess the first thing I want to go to is on November 17th, 2023, a news report revealed that you were investigating Mrs. Verschuren, the conflict of interest. And then on November 20th, she resigns. So when did you actually officially begin your investigation on Ms. Verschuren?
So we received the complaint on November the 10th.
Okay.
And let's see, we wrote on November 16th to launch.
Okay. So would Ms. Verschuren know about that? Was she notified that she's in an investigation? And
the process is we write to her, we say we're starting an investigation, and we would like, and we point out we want to interview her and hear the issues and what we want to discuss with her.
right, so that would have been done shortly after November 10th or November 16th. Would that have been the?
Yeah.
So basically, she gets the letter, then she resigns. That's, so, yeah.
But
Does that happen often? That you actually write to somebody and say, we're going to actually investigate you, and then within a matter of hours, they resign from their position?
I've only been in the position 1 year, so I can't tell you, but maybe my colleague has a better memory.
Yeah.
I mean, to my knowledge, I don't think it has happened in the past, but I don't know what would have precipitated resignation in this case either.
No, and I'm not asking for that. I just think, though, that, I mean, I haven't seen such a rapid response to something like that in my past. I could be wrong, and I mean, I could easily go find out, I guess, if we looked at detailed information of other cases. I guess one of the things I'm concerned about is that she declined, let's go through the things that she did. She declined the conflict advice. She didn't leave the room, and a whole series of different things. But of all those things in the boardroom at that point in time, was there any consequence within SDTC for her or for colleagues that knowingly saw this behavior and said nothing? Is there any actual consequence to those board members and or for herself, the failure of actually reporting or pointing that out? Because, you know, there can be willful consent by people just not saying anything. I've been in lots of rooms where people know people have either said or have done or acted the wrong way, and people have just let that pass and go by because it could be over an issue of sexism, racism, inappropriate behavior. It could be, in this case, voting. But what were the consequences on the board members for the system set up in place?
The way the system works is, in effect, when there is a violation and we are made aware of it, or we investigate our own, then we can expose it and we make it public. That is the penalty. That your reputation essentially is damaged by the report that shows that you have done that. In terms of the interaction in between the board, etc., all we have is a record of what happened and the testimony of the people whom we interviewed. And so I can't answer your question. I don't know whether there was willful looking away, as you suggest, or whether there was benign ignorance or what.
Okay. So, I mean, this is where some of the concern for accountability that I've had about this file is because this was set up over 20 years ago, and it's lived through a number of ministers that have left here in disgrace, including Minister Bernier and Mr. Clement and others. And we still have a system in place, potentially, that allows for this type of conduct and behavior consistently and an openness there. And I think I would agree that we still would want to shed the light on the truth. And the reason, I guess, to answer your question that went to Mr. Perkins, is I believe that it needs to be followed through is because how do we then actually show the public the actual full damage that this malfeasance takes place from these corporate boards and agencies that are set up arm's length distance, often on purpose. And I wanted to point out that the staff are fully funded by federal taxpayers, but they didn't enjoy the same privileges of protection for whistleblowing, nor benefits, nor union, and nor so forth in terms of the workplace. How do we actually, you know, dispense from everything when we don't know the full damage of what took place from the actions of this board?
When you say the full damage, to the extent there was damage, you have the public, you have the report of the Auditor General. If I would investigate these people, all I could prove that they had, assuming you're correct, on various occasions violated the Conflict of Interest Act. What would that add in terms of the public knows right now the report is out. It's a very damaging report. The whole board resigned. As you know, it's been moved to the NRC, etc. There have been consequences. I don't feel there would be anything added by my going over past activities of people who have resigned, who are no longer in that position, said while you had that position, you misused it.
Sure. I guess from my perspective, from lay people, is that there's more than just the exposure here of an individual and her behavior that have, obviously you've ruled on, and then the others that were around her. It's maybe a structural problem with some of these boards and operations, and I think a full continued thorough examination of the situation should expose some of that, because I'm willing to bet this isn't the only situation where we see malfeasance and irregularities and boardroom minutes that aren't completed or not reflective, and when it deals with taxpayers' money. I would prefer to see this finished for those reasons, Mr. Chair.
Thank you, Mr. Massé. And I will now yield the floor to MP Barrett for 5 minutes.
Commissioner, Mr. Keno, good to see you. I have a hypothetical question for you. If a designated public office holder like a minister had a financial interest in a company like Telesat, and Telesat, which just received a more than $2 billion loan from the government just days ago. Would that minister need to have recused themselves? What would that look like for that minister with that interest in Telesat?
You're asking me, as usual, sorry, not as usual, as you have before, theoretical questions. I gladly answer a factual question. The theoretical one, you'll have to give me far more detailed facts before I can answer. You say
okay.
There was a grant to Telesat.
Sure.
By who? By cabinet decision? On what base? Under what authority? Who was the minister, etc.?
So, just this past week, Justin Trudeau announced that Mark Carbon Tax Carney is going to be advising him on all matters finance. And days after, a company that Mr. Carney has a financial interest in received $2.14 billion in an announcement by the Prime Minister. Mr. Carney has been hired by the Liberal Party, it appears, to avoid the scrutiny of the Conflict of Interest Act. Does this present as skirting of the? It clearly presents as a problem to Canadians. Is Mr. Carney a ministerial advisor by the definition set out in the Act?
No, because he is advising the Liberal Party. What the Liberal Party does or does not is not government action. The government may adopt the advice that was given by Mr. Carney, but in effect they're adopting the advice of the Liberal Party who got it from Mr. Carney. It's the way they structured it right now. He is not a ministerial advisor. So
it's an appropriate practice then for parties to provide, we would imagine, non-public information, for the government to provide non-public information to their employees at the party when those employees have serious financial positions in companies that could stand to benefit from that information.
Well, the party gathers information from all sorts of sources, etc. They can pay for it, they can get it for free, etc. They then use that information in order to position themselves and decide on their policy. That is a perfectly normal procedure. There's nothing of conflict of interest here.
So there's no conflict if Mr. Carney receives non-public information from the Department of Finance and then uses that to provide advice to the government because he's employed by the party and not paid by taxpayers, though the advice that he provides could materially benefit him and his other.
Your supposition is that he receives non-public inside information from the Department of Finance.
Point of order, Chair.
That's just a supposition you make. I have no proof of that. If that is
excuse me, Commissioner.
That would be a different situation.
We have a point of order. I'll just...
Sorry to interrupt, Commissioner, but I just find it a little bit troubling that Mr. Barrett hasn't asked a single question about SDTC. He's using hypotheticals to ask the witness a question, which is great, but it's not what we're here to study. My understanding, I know he supports, world-dominating billionaires, but that rather than Canadian companies, but that's not that's not the axe that he should be grinding today. It's SDTC.
Is it a point of order?
It's relevance.
Thank you, Mr. Turnbull. Thank you, Mr. Turnbull, and I accept your point of order in that we had a 1064 meeting to call for this 3-hour special meeting to discuss the Commissioner's report on SDTC. So I'd ask you, Mr. Barrett, although I am generous in terms of the questions that can ask, to try to be relevant to the topic for which you had a whole lot of resources deployed this summer to bring this meeting forward specifically about this topic. So please keep those rules in mind. You know the rules of relevance. And I'll yield the floor to you back. You have a minute and a half.
I agree that Mr. Turnbull is quite troubled, Chair, as he stated. When we're talking about conflicts of interest like Ms. Verscherian, you can check the box there, Ryan. Randy Boissonneau's company, Global Health Imports, was given $30,000 on December 30th, 2023. Minister Boissonneau was a 50% partner in that company. Were you aware of that?
Sorry, when was
Point
it
of
given?
order.
Yes, Mr. Turnbull.
I thought the topic for this meeting was SDTC. Is the
I'll bring
witness
it-
answering questions
I'll
on
bring it
any
back.
topic that Mr.
That
Barrett
was
so
15
chooses,
seconds.
or is this an actual focused discussion?
Thank you, Mr. Turnbull. And yes, I agree with that point of order. Mr. Barrett, keep it on the topic of the meeting, please. Thank you.
It was December 30th.
That was a company you're talking about, the contract from Election Canada?
Yes, sir.
Yeah. There was a company in which he was an owner. At that point, he is no longer an owner of that. Just being an owner in a company, he had no involvement with the operation of the company. We have looked, as you know, at his involvement.
But were you aware at the time that that had occurred?
No. It came out. I read it in the press as you, but I'm sorry. In Elections Canada was buying, I think, masks or gloves or something like that, for $30,000 through.
Is it not a violation of Section 13, Sub 2 of the Act?
How is it a violation? He's not running a company. Can he not?
It says they can't have an interest in a partnership or private corporation that's party to a contract with a public sector entity.
Thank you, Mr. Barrett. That's all the time you had, and I would now yield the floor to MP Turnbull for 5 minutes.
Thanks, Chair. So getting back to SDTC, Commissioner, what is the effective difference between abstaining and recusal? I'm kind of interested in this. Like, did Ms. Vishurin actually influence the decision-making of the board when they were approving funding decisions for her benefit? Because to me, that would be a serious violation. Did you see any evidence of that?
And first of all, the distinction between the idea is that while you are in the room, people may not speak openly about pros and cons of a motion, or may not want to vote, and therefore incur your disfavor. So therefore, when you have a conflict, the idea is get out of the room. If it's virtual, get off the web, so you cannot participate and the people can freely vote. And that's what the Act establishes, etc. Here, there's a couple of times she voted, while after abstaining, she voted, still voted. And did she benefit from it? No, we are not that we have any evidence. It was, I would call it more a technical violation. You know, you are supposed to abstain. You are supposed to recuse. You didn't. You abstained. And I made that quite clear in the report that it was a contravention of the Act. But it was no more than that.
So it wasn't intentionally manipulating or influencing the board for her own personal benefit. I think that's kind of what the Conservatives keep claiming. I just wanted to get from you your perspective on whether that's what the evidence actually suggests in this case.
No, it did not suggest that.
Thank you. Let me ask you another question. So during your appearance at the Public Accounts Committee, one of my colleagues filled you in on a recent letter from the RCMP Commissioner to the House Clerk on a Conservative House motion that was adopted on June 10th, 2024. With this letter, the RCMP Commissioner sounded the alarm, saying that the House order is interfering in the operational and police independence.
Point of order, Chair.
Let me just read this quote from this letter.
MP Turnbull, I have a point of order from Mr. Barrett. Yes.
I appreciate that in your previous ruling you provided a very narrow scope on what we're to engage in with respect to exactly what was in the 1064 meeting and motion that was adopted, and we don't need to look very far to see that though Mr. Turnbull is going to go down a path that's not consistent with that, that we'd look to apply your ruling the same to particularly what we're here to discuss.
You've got powers I don't have, Mr. Barrett. You can read the future saying Mr. Turnbull will go down that path. I'm not entirely sure he will, but and also you misread my ruling. I've told you I'm pretty generous in the leeway, and you're new to this committee. You're here, but members know around the table. I'm looking around the table that I'm pretty generous in how I interpret questions and the leeway I give members to ask questions that sometimes deviate from the motion. But considering that a 1064 had members come back in the middle of the summer to discuss this specific issue, I'll still ask member to try to focus on SDTC, which is the reason why we're here. But I've been very generous with your line of questioning, Mr. Barrett, you will have noticed. So I'll ask Mr. Turnbull to keep in mind the point of order that the judgment I just made a couple of minutes ago.
Thank you, Chair. I will. So, and this letter is particularly pertaining to SDTC. It refers to both the Auditor General's report, and it's from the RCMP Commissioner, Mike Duham. So I want to quote from this letter. He says, there is significant risk that the motion, i.e. the Conservative motion, could be interpreted as a circumvention of normal investigative processes and charter protections. He goes on to say, in the last paragraph, I would like to emphasize as well that the RCMP is operationally independent and strictly adheres to the principles of police independence. In a free and democratic society, this ensures that the government cannot direct or influence the actions of law enforcement, and that law enforcement decisions remain based on the information and evidence available to police. So I wanted to get your perspective on this, but I also will reference the Auditor General has sent a similar letter with a similar reaction. And the concern is that agents of Parliament, i.e. in this case the Conservatives in their motion, are essentially eroding the independence of key officers of Parliament. And independent institutions. So, Mr. von Finkenstein, I would like to get your perspective on this.
And the Commissioner of the RCMP, of course, is very concerned to make sure that any evidence he presents and is used can be used in court. It won't be thrown out for whatever reason, for principally a violation of the Charter or of being not obtained properly, etc. On the other hand, of course, you have the principle of Parliament. Parliament is supreme and can look into things if they want to. And what he's pointing out in his letter is that what the committee has asked for could potentially cause problems down the line, and he wants to, in effect, alert you to it. And he's quite right. These are two difficult principles to reconcile. They can be reconciled, but you have to be very careful. And he wants to make sure that nothing impeaches his duties as an independent law enforcement. But on the other hand, of course, he's very careful, not wanting to tread upon your privilege as a parliamentary committee to ask for whatever you want. So both parties, if they're aware of the problem and act carefully, these actions can be reconciled.
Are there, so there's other scholars.
Sorry, Mr. Turnbull, that's all the time you have. Okay. 5-minute round. I'll now turn it over to Monsieur Garon. La parole est à vous pour 2 minutes 30.
The floor is yours. 2.5 minutes, Mr. Garon. Mr. Commissioner, my question, I understand that your role is to review the situation, determine whether there's been violations of the Conflict of Interest Act. I understand that role. But we're talking about a broader context here, when on a number of occasions, in the case of SDTC, the government creates these kinds of organisations without actually naming who all the individual board members are. And you said that that's a decision made by the government. And you've indicated that these directors aren't public office holders under your mandate, such that you would investigate them systematically. But despite all of that, I'd still like to ask you this question, and I'd like your opinion on this. In your opinion, does SDTC, or the Minister of Innovation, Science and Economic Development, did they have the means in the department to prevent these practices before we heard whistleblowers report on them? Response. Well, verification can be made if it's requested, but I don't know whether any verifications were carried out or not. But as the owner of the company, she could ask for what she wanted for. Well, let me come back to the integrity of the parliamentary work that we do here. When we had the former minister appear before us, and I asked him this direct question, his response was quite straightforward. I had no tools at my disposal that would have enabled me to prevent this kind of situation. Now, in your opinion, that's a lie? Well, the government... Well, there's the individual in charge of those activities. I'm not quite sure which testimony you're quoting exactly. Well, he lied, basically. Mr. Chair, do I have enough time for one final quick question? Now, between abstaining and recusing oneself, could you please just confirm that my understanding is correct? Perhaps I don't vote, but I remain in the room and have and influence the votes of other directors. That's where the conflict of interest lies, isn't it? Yes, that's correct. Thank you very much.
I'm trying to understand a little bit about the responsibility of the culture of the board. I'm not as familiar with some of the corporate boards and structures. I'm a New Democrat. We don't get appointed to those positions. So we have to live with the folklore that we hear. And I just having a hard time wrapping around the ability for people to escape for knowing what should be there. Would you, in your opinion, be kind of a basic thing for all the other board members to understand the rules and obligations there about absenteeism, or were they all abusing this, or did some just kind of do it, and was it a mixture of a dog's breakfast, so to speak, of behavior? I just find that hard to accept, because these are a lot of the times political appointees, and you would think that there would be some type of understanding and appreciation of public responsibility at the end of the day. So walk me through, in the boardroom, what do you think happened there, and do you think those individuals abstained themselves from their conscientious job of overseeing taxpayers' dollars?
I can't tell you what happened in the boardroom. I can just say the way it is. It's a company. It has its own code of conduct and conflict of interest. Very good one, which, by the way, incorporates the act and says you have to comply with it. Then you have a corporate secretary who informs all the members when they're appointed. Here is a code of conflict. This is what you have to comply with, and please sign, etc. Then if they want to, they can ask us and say, would you give us a presentation on the act, and we'll gladly do that, etc. And then the board, and these are all, don't forget, these are businessmen. They sit on other boards. This is nothing new to them. They know that, if there's a conflict, you have to declare it. And if they had been properly instructed, not only declare it, but get out of the room.
Okay.
If they presumably, so in other companies, you can stay there as long as you abstain. Depends on what the internal rules are, etc. Here, I really don't know to what extent they were briefed, they were taught, and reminded of it. Strangely enough, this outfit did not have a corporate secretary. They only had a recording secretary, which is, I don't know how you run a company without a corporate secretary, because he usually calls the meeting, brings the documents together, informs everybody, etc. But that's how they operated. And I don't know to what extent there was emphasis on conflict of interest, to what extent. Now, Michael, you looked at all the minutes. Please supplement.
Yeah, I mean, to the extent that the issue or the decision involved startup funding, or the more important financial decisions, the board by and large recused, properly recused. It was noted in the minutes. They left the room. I think what the commissioner's report showed was that there was a fundamental misunderstanding in two key areas. One was involving the consent agenda, which also included spending items. Those should have been voted on independently, individually, so that would have allowed the conflicted board member to properly recuse on those as well. But instead, they were treated as a lump, a bulk vote. And on the matter of the COVID votes, they were instructed incorrectly. And that was the source of the conflict there.
Merci beaucoup. Monsieur Brock, la parole est à vous pour 5 minutes.
Mr. Brock, the floor is yours, 5 minutes.
Mr. Chair, Commissioner, at committee in July, you indicated that you had in your possession and were reviewing 9 text messages from Randy Boissonneau's business partner, Anderson, 9 of which name a Randy, and one of which places this Randy in Vancouver at, coincidentally, the very same time that the
Point of
Liberal
order.
cabinet was meeting.
Relevance. Come on.
Thank you, Mr. Turnbull. Mr. Cooper, there is a point of order that has been brought that's been discussed before. I would encourage you, I will ask you to stay on the topic that we're discussing. However, if this topic is of interest, you can always bring it up at other committees or on a 1064, just like it was done for this committee to meet on SDTC. I find it a little disrespectful to the time of the committee that you would be.
Just if I may reply to the point of order, the question, I haven't even had a chance to pose my question. If I had been given that opportunity, it would be apparent that it is in fact tied to the issue before this committee.
Please tie it to the matter at hand.
Yes, yeah, because it goes to a question about whether, Commissioner, now that you have the 9 text messages naming Mr. Boissonneau or a Randy, we have not 1 smoking gun, but 9 smoking guns. So since July, have you opened an investigation into Randy Boissonneau contravening the Conflict of Interest Act?
Point of order. That is not relevant to the topic at hand, Chair. That has nothing to do with SDTC, which is the topic of the meeting today. I know Mr. Cooper and his Conservative colleagues have a hard time reading the motion, perhaps, but this is on SDTC.
The commissioner said...
Mr. Cooper doesn't like hearing from me because we've had many battles for many committees, but this is not relevant.
I know Mr. Turnbull wants to cover up
Mr. Cooper, you don't have the floor. I've listened to the point of order brought forward, and it's, again, the same thing. It goes to relevance. I'm very liberal in how I interpret the topics that are discussed. I'm generous. However, I can't tie it to the subject at hand. And Mr. Perkins, with colleagues, brought us in the summer on a 1064 to take 3 hours of the committee time to discuss SDTC. I'd like for us to discuss SDTC, so please, Mr. Cooper.
Commissioner, are you investigating Mr. Boissonneau for violating the Conflict of Interest Act?
No.
You're not. Now, going back to the study at hand, you said, Commissioner, that what is the point? What is the point of investigating someone like Ms. Verscheren, who is no longer in her position? Here you have a sitting minister who potentially violated the Conflict of Interest Act with not 1, not 2, but 9 smoking guns, and 2 months later, you haven't bothered to do anything further. Is that what you're telling this committee?
First of all, as you know, before I investigate, I have to have reasonable grounds to investigate. What you have here is a bunch of emails. Can I finish?
9 emails that name a Randy, one that just coincidentally happens to connect him to being in Vancouver, and you say you don't have any grounds? I'm just shocked at the lack of interest, the lack of curiosity of a sitting minister who may have contravened the Conflict of Interest Act.
Mr. Cooper, I'll ask you to let the witness. I'll ask you to let the witness respond. But at the same time, this is so far from what we're supposed to be studying, Mr. Cooper. Have you read?
What's the point?
Have you read the motion?
He said that with respect to Ms. Verscheren. Now I'm talking about a minister who's in his office, and he's not interested in investigating the minister. He's not interested in investigating Ms. Verscheren. He's not interested in investigating the minister. What is he interested in investigating?
Yes,
is he interested in actually enforcing the Conflict of Interest Act?
Mr. Cooper, I understand you're not a regular member of this committee. I'd appreciate if maybe the Vice Chair, Mr. Perkins, could brief you on how we do things around this committee. But we don't interrupt each other. We don't interrupt the Chair for one. And we talk when we have the floor. I haven't given you the floor. There's a point of order that's been raised, a very valid one, on relevance, and I think your questions are just not relevant.
I know Mr. Turnbull wants to run interference to protect Randy Boissonneau, and it appears you do too as well, Chair.
Mr. Cooper, well, that is just however, peu importe, Monsieur Cooper, comment vous voulez l'exprimer.
Regardless of how you put it, Mr. Cooper, I don't really care what subject you're wanting to pursue here. The committee is sovereign. If you want to pursue this topic, that's fine with me, but there's to be a motion voted in by the committee to determine that would be the course of action.
Questions you're asking, the Commissioner, we can. We just need to adopt a motion in that direction. This is not what we're supposed to be studying today. That's as easy as that. Madam Jones, on your point of order.
Thank you, Mr. Chair. And of course, my point of order is on relevance for probably the third time since we started the committee with some of the same speakers that have had to be raised. I just want to note for the record that there is always opportunity to approach the commissioner on other issues outside of the committee forum, and today we're discussing a very different matter. So the commissioner is here to answer questions on that matter. That is of vital importance to the committee, and I would really appreciate it if members could stick to the study and the topic that we're debating.
I agree, and so I'll ask you, Mr. Cooper, you still have 2 minutes 56 seconds to stay on the topic, and if you haven't seen the notice of motion or if your fellow members haven't shared it with you, please have a look at it. We came here during the summer on a 106.4 for that very special meeting. So, Mr. Cooper. Yes, Mr. Barrett.
So I did confer after you had instructed me to perhaps consult the notice of motion to confirm it hadn't changed, and the direction that Mr. Cooper went to deal with the analogous situation between what Mr. Perkins had raised and the response from the commissioner and the comparison to another decision of the witness was what we were looking at. I checked. The notice of motion is exactly the one that was passed in the summer, based on the motion that was passed at the 106.4 meeting in the summer. So you can rest assured that I did read it, and I understand that the standing orders are the same at all of the committees. So I appreciate the guidance on and being welcomed here. But with respect, Chair, the analogy that Mr. Cooper was drawing is absolutely not any further than the analogy that Mr. Turnbull was to drawing to SDTC in the House, which did not deal with the conflict of interest that we're talking about with Ms. Verscherian. So equal opportunity to draw analogies or to deal with subjects related to would be appreciated. That's all that we're looking for, but I can assure you we were well consulted, and Mr. Perkins briefed us very well on the standard operating procedures here at your committee.
Appreciate that, Mr. Massey. Did you have something to add on this point of order?
Yeah, just a clarification of how much time we have left. I know the Conservatives are filibustering each other at the moment, but at the same time, we only have the witness here for a certain amount of time. I wanted to confirm how much time we have left in that.
Well, it depends. We have about until 4:35 with the witness. The points of order have eaten up a lot of time, but I can still give a minute to Mr. Cooper and then or to Mr. Brock if he wants.
Well, I'll turn it over to Mr. Brock.
Well, it depends. The time we're taking with the commissioner will eat on the time we have with Madame Verschuren, which I think is of interest to the committee. Mr. Brock, go ahead.
For your appearance, I want to drill down and set the stage for Ms. Verschuren's appearance on the issue of her knowledge of recusal versus abstention. Now, she said quite proudly when she testified on the 12th and 14th of December 2023 that she's been a board member on various boards since she was 38 years of age. She's extremely familiar with conflict of interest policies. She's recused herself on numerous occasions. And then she said very proudly, I am sure that I didn't break ethics laws. That was December 14th, 2023, before the release of your report. Now, I know that she spoke with a compliance officer in your office on June the 4th, 2019. Obviously, the issues of recusal and abstention were discussed. So clearly, Commissioner, you weren't the compliance officer that she spoke with. Is that accurate? Okay. Are you satisfied that consistently your compliance officers would have explained in simple language the clear distinction between abstention and recusal?
I cannot answer. The only record we have is that she called and spoke to one of my officers. Unfortunately, that officer has since left, and the email in which she reported what her conversation with Ms. Verschuren is no longer there, because we erased it once she left. So I honestly don't know what she discussed, to what extent she explained to what they talked about. All I know, it was a very short conversation between her and one of my officers.
Okay. But you'd have no reason to suggest that for any particular reason that compliance officer would have deviated against your office's policies in terms of having that discussion with ordering council appointments?
If Mrs. Verschuren had asked, what does recusal mean, she would have been told, leave the room. There's no question about it. Did she ask? I don't know. I have no evidence what the conversation was about and what it concerned. I mean, when a public officer is newly appointed, they may have all sorts of concerns, and that's why they phone us. It's unfortunate that unfortunately I have no record of what was discussed.
Because I'm referring to page 30 of your report, paragraph 141, where you talk about the distinction between the two terms as explained in the Morneau 2 report. Very simple language. I think moving forward, you might want to, as a suggestion, it's obviously entirely up to you, Commissioner, but as a suggestion for future discussions with these appointees, having that simple language explained in light of the classic examples that she demonstrated, where she took legal advice as opposed to stating to you that she understood her compliance with not only policy, SDTC policy, but the Conflict of Interest Act were paramount. She's now relying upon extremely poor legal advice.
Thank you, Mr.
So I think it would be helpful in the future that that distinction is made known to all of those appointees.
As I mentioned in my opening remark, we just issued an information notice to everybody exactly on that point, and in plain language. Recusal means leave the room, physically or virtually.
Right.
You know, I can't say it cleaner than that.
I agree. Thank you.
Thank you, Commissioner. MP Gahir for 5 minutes.
Great. Thank you, Chair. Thank you, Commissioner, for appearing before the committee. I wanted to ask about your role more generally. We know that SDTC it's an arm's length, not-for-profit foundation that was created by the Government of Canada. So in your purview, how do you keep an eye on sort of not-for-profit foundations, other arm's length organizations, bodies within the Government of Canada?
It's not the body, it's the people appointed to it. But I look at MPs, elected official ministers, their assistants, and people appointed by order in council. And when the order in council is issued, it will qualify them as either public, as reporting public officers or public officers. Public officers means you have to comply with the Act, point final. Reporting public officer means you have to come to me, you have to fill out a long questionnaire, I tell you what to do or not, you have to report to me if anything changes, you may have to sell certain things, and you have a person appointed in my office who's solely responsible for you, and you can call them and get advice anytime.
So as MPs, we also have to fill out the same questionnaire, so I'm very familiar with it. Do you only look at reported cases of conflict, or does your office engage in anything proactively?
No, I mean, the two things, cases can be referred to me, especially by members of parliament, or there has to be reason to believe that a public office holder or former public holder has contravened this act. If I have reason to believe that it's a preliminary thing, then I can say I want to make an investigation. If there isn't, or if there's some vague suspicions or allegations, etc., but they don't amount to reason to believe, then I don't do it.
So
I'm discretion vested in me to decide whether there's reason to believe.
Sure. So I'm a lawyer. I think many members of this committee are lawyers as well. I'm just wondering what amounts to reasonable grounds to investigate. Is that like a more than likely standard?
Yeah, it's more than mere suspicion, and it's short of reasonable grounds. Of sort of, I mean, the act is vague because there is more than, I think your definition was probably about the right one.
Yeah.
It's more, there's a likelihood there, and that's why you.
Okay. And so the parties that are being investigated by your office, do they know that they're being investigated, or?
You're informed. You can bring your counsel, which you normally do. You're put under oath, and then we ask you questions, and then we may want to ask certain records. We have the power to issue subpoena duces tecum to get everything, and we can also subpoena third parties.
Mm-hmm. So do you think it would be fair to say that if there's not been a complaint by someone or a third party, or your office has not picked up on something that's off in the disclosure itself, your office generally will not know if there's misdoing or misgoings?
Yeah, I know. We won't know unless it's something in the public. Usually, it may somebody informed us, or else there's something in the papers or on TV or something that is sufficient to meet the threshold I just mentioned.
Okay. So I think because we've seen this line of criticism from the Conservatives as well, but they keep claiming that you, as a Trudeau-appointed commissioner, failed at your job by not sufficiently keeping an eye on Ms. Verschuren throughout her appointment. I think the questions that I've asked have clearly shown that your job is not to sort of keep a proactive eye, but it's through disclosures or through complaints that reach your office, correct?
Well, I'd like to take objection to Trudeau appointed. I was appointed by Governor and Council, and the appointment was approved unanimously by House of Commons. So I'm not partisan in any way. I was appointed because of my former history in the public service. And, as I say, all parties agreed to it. My job is to honestly and objectively administer this act.
And then on the criticism that you were to proactively keep an eye on Ms. Verschuren, I think your answers have clearly shown that is not in the purview of your office.
No, I essentially act on either information that is sent to me, or if there is something that's in the public domain that is sufficient to trigger it of giving me reason to believe that a conflict of interest has been. But I'm not doing and it's in supervision of people, not of organizations.
Great, thank you.
Thank you very much, MP Gaillard, and thank you, Commissioner. Thank you, Council, for your presence here with us today. We're off to a great start to this session. And on that, we will briefly suspend, and we'll be right back in about 5 minutes with an adversary. Thank you. Meeting suspended.
Colleagues, we're going to resume. We're welcoming Annette Verschuren once again to the committee, and thank you for being here, Ms. Verschuren, this afternoon for this first meeting of the parliamentary session. And as you're aware, you have 5 minutes for your opening comments. Without further ado, I'll yield the floor to you.
Oh, and Madame Verschuren, I believe you're on mute. Still appear to be on mute. There you go.
Mr. Chair, honorable members, thank you and good afternoon. I was pleased to accept your invitation to discuss the findings, analysis, and conclusions contained in the Commissioner's report. I want to emphasize to this committee and to Canadians, on the day of the report's release, I immediately accepted the findings of the Commissioner, just as he accepted that I acted in good faith and that I properly sought legal guidance to ensure compliance with all established guidelines. I'll say it again. I accept his findings, all of them, just as he accepts that I at all times acted in good faith and with the best of intentions. Since we're here to discuss the Commissioner's report, let me go right to the source. In his report, the Commissioner concluded, and I quote, "In my view, Ms. Verschuren took what she believed at the time to be proper steps to ensure that her interests did not interfere with the exercise of her official duties as chairperson of SDTC. She believed at the time that she had acted within the bounds of the Act." End of quote. Later he concluded, and again I quote, "There is no evidence that Ms. Verschuren attempted to influence the decision of her colleagues on SDTC's board." End of quote. He also concluded and said, and again I quote, "It's unfortunate that a lack of consistency in decision-making processes at SDTC, coupled with incorrect legal advice, caused Ms. Verschuren to deviate from standard practice." End of quote. To the members of the committee and to Canadians, I say, I trusted the professional and experienced legal advice that I was given. I followed established SDTC board practices that predated my tenure. And at all times, I took what I believe to be the correct steps. In the eyes of the Commissioner, those established practices were flawed. That legal advice didn't go far enough. I abstained from voting when, in his view, I should have taken the additional step of recusing myself. I accept his findings, just as he accepts that I acted in good faith and adhere to what I believe to be the proper set of measures. Thank you, Mr. Chair. I'm happy now to answer your questions.
Merci beaucoup, Madame Verschuren. Je passerai maintenant la parole à Monsieur.
Thank you. The floor is Mr. Perkins. To get things started, 6 minutes.
Mr. Chair, and thank you, Ms. Verschuren. Ms. Verschuren, when did the Minister's office approach you to consider being the chair of SDTC?
I don't know exactly the date. It was a couple of times I think he spoke to me about this, as did his policy advisor, I believe, as well.
You're referring to Minister Baines?
Yes, Minister Baines.
They called you to see if
Yes.
you would do this. And
Yes.
your testimony, or at least what's reflected in the Ethics Commissioner report, in your interviews there, said that the government approached you. Is that correct?
That's correct.
But Minister Baines, when he appeared before this committee, said he had nothing to do with the appointment, that he had been given a list from PCO, and that you had applied. Now, is that true? Had you applied before you spoke with Minister Baines or after?
Mr. Chair, I never applied for the position of the chair of SDTC.
Thank you. Thank you. Thank you. That clarifies a lot of things about Minister Baines' testimony here. and the cover-up on this. So now with regard, if I could ask you a few questions. Well, I appreciate that you appreciate the Conflict of Interest Commissioner's review, very narrow review of the circumstances. The Conflict of Interest Commissioner just testified here that actually he didn't cover all of the conflicts that were identified by the Auditor General in her report. Indeed, he did not say that there were 2. They confirmed here there were 24 instances of conflict of interest for yourself, not 2. Do you agree that you had a conflict of interest at least 24 times?
Mr. Chair, I accept the Commissioner's findings. Just as he accepted in his report that I acted in good faith on legal advice and established board practices that predated my tenure.
Yes, and we have testimony from the former president, Leah Lawrence, who said before this committee that when she tried to improve the governance structure and governance policies, that you as the head of the board and the board itself rejected those attempts.
Mr. Chair, I do not recall those conversations.
So on the conflicts that were outlined by the Auditor General, the Auditor General took a sampling over 5 years of 226 projects during the time of the 5-year audit. There were over 400 that the board approved at the time, but took a sampling of the 226. And out of that 226, 186 votes in the board had a conflict. In other words, 82% of the sample that the Auditor General took, board members were conflicted. Now, it sounds to me like the board members were overrepresented in the allocation of the $800 million, roughly, $836 million that those votes represented. 82% were going to conflicted board members. So we've had, again, testimony here before the committee that when you were appointed with a managed conflict, the first chair in the history of the SDTC to have a conflict and appointed to the chair of this board, that the culture changed. In fact, fellow board members and the former president testified that one board member said, oh, we can manage conflict, so I'm going to bring some projects back. So isn't it true that your leadership created a culture of conflict of interest that led to 82% of board members receiving a vast majority, over $330 million, to their companies that they were conflicted into? That wasn't happening before. So while you say it was done innocently, when 82% of board members, including yourself, are voting for things that you have a conflict of interest, that doesn't look innocent. That looks like a plan.
The investments that STTC made over the years were all invested in projects that included capital for labor, for capital equipment, all investments that were spent and audited, and an enormous amount of due diligence that went into the process.
Are you telling me that the few board members that were on that board, 9 were identified by the Auditor General that had conflicts of interest, that those 9 represent 82% of the invested interest in green technologies in Canada? Because there is statistically no way that that's true. So the result is, if your interests were represented 82% of the votes, your being the board members and the board that you led, there was something here going on that was way different than what the public office holders should allow.
The decisions, the STDC undertook a lot of due diligence. The commissioner referred to technical violations in his report on the work that he did with me. I think that there are
82% of votes is not technical breaches of conflict of interest. It's real breaches. When one particular board member's conflicts led to over $200 million to go into her companies over the time that she had it, over $100 million while she was on the board. Same thing with Mr. Emet with about $10 million, Mr. Kukucher, $25 million. This appears to me to be a systemic plan and group think that says, together, it's okay, because we've all got managed conflicts. You leave the room when it's yours up, I'll leave the room when I'm up, and you leave the room. It must have been tough to get quorum there since so many of your directors were conflicted.
Okay. A brief answer, Ms. Verschoren, and then your time is up, Mr. Perkins.
We obviously followed the processes that were in place. We obviously declared our conflicts. Critically important that we followed those, and we followed procedure. STTC is a organization that really did work and invested in the entrepreneurs in our country.
Thank you. MP Area.
Thank you. I'm an immigrant. I came to this wonderful country 20 years back. One of the things I was proud whenever I go travel abroad, meet my family, relatives, and friends in other countries, always say that Canada is corruption-free. And I can tell you, with my knowledge of a lot of my colleagues in the House of Commons, I can say that they are corruption-free. But unfortunately, the actions that I've been seeing lately with your actions, that is something that I can't defend. One instance I can say that it is a mistake. Second instance, we can say that, okay, that can also be considered mistake, but 24 times, it's systemic. And when we include the fellow board members and 82% of the time, then it is insiders club. Canadians trusted arm's length. The government of Canada, when they formed STDC, they made it arm's length so that they can get professionals to manage the tax funds, very ethically and productively, out of the decision making away from the politicians. But you and your board, you destroyed it. I joined politics with 3 objectives. My third objective was to ensure that Canada remains forefront of the knowledge-based economy that's happening world over. I was on the board of Invest Ottawa, where one of the major objectives was to promote knowledge-based industries in the city of Ottawa. When STDC was first formed, I was very happy. Many of us were very, very happy that the clean technology is getting the boost that is needed. But in one stroke, or rather in few strokes, you and your fellow board members, you have destroyed it. I'm very sorry to say that. As I keep repeating, I have told earlier, one time it's a mistake, but not 24 times. Even now, do you think that after reading the Commissioner's report, do you think that it was sort of a technical mistake? Or, in fact, let me go back. I did look up the difference between conflict of interest and corruption. Very thin line. There's a lot of gray areas. But when the number of instances of conflict of interest happens in a short period of time, happens amongst very few members, then it goes on the side of corruption. Do you agree with that?
What happened here was, in terms of the designation of abstaining versus recusing myself in terms of the conflict of interest. That was the thing that the Commissioner identified that I did not live up to, and I should have lived up to that. I recognize that. But I have no direct interest in any of the companies other than the one that I declared 18 months before I became chair. No interest in any of those organizations, no direct interest. Perceived conflict, yes, but no direct investment.
So what you're saying is that you had conflict of interest, but no direct investment. I was in the private sector before I got elected. I understand many times how things work. You scratch my back, I scratch yours. And again, if it was a simple mistake of definition of declaring conflict or recusing itself, if it is limited to that, I would have agreed. But the numbers speak. Numbers doesn't give us any comfort. 24 times and 82% of the board members. How can this continue to happen? I'm so sorry. This has resulted in a great institution, in my view, that was formed with very good objectives in trying to promote the clean technology in Canada. Now it is getting destroyed. Are you happy with the outcome of this? What happened to the fund that was there to promote clean technology, and what has happened today? Are you happy about it, or what is your reaction to that?
It is my understanding that STDC is going to be managed in NRC, and the minister has made those moves to continue to sustain and operate that organization. It is a great organization. We are aware that there are investigations going on today to dig into this area and to look at the processes at STTC and how those investments were made and how those conflicts were declared.
I understand that NRC is administering it, but I do have good respect for the professionals at NRC and other departments in the government, but they are bureaucrats. The purpose of setting up STDC and bringing in professionals from the private sector was that the people dealing with cutting-edge technologies who can understand the new technologies, who can who can envisage the importance of technologies. The entire premise was that the professionals from the private sector will take this thing further. Government bureaucrats can do, but they don't have the same sort of knowledge, expertise, and connections within the industry to gather what's happening there.
Thank you, MPRA. That's all the time you had. Monsieur Garon, la parole est à vous pour 6 minutes.
The floor is yours, Mr. Garon, 6 minutes. Thank you very much, Mr. Chairperson. Ms. Verschuren, I'm a tad shocked by your opening remarks. I read the Conflict of Interest Commissioner's report. We've all read it. And this is a very severe criticism of you, an indictment of your management. It's testing 1, 2, 3. This is the interpretation. Testing 1, 2, 3. Testing 1, 2, 3. Wanting to make sure that the interpretation is working. Please resume, Mr. Garon. Well, thank you very much, Mr. Chairperson. I was saying, Ms. Verschuren, is the interpretation working? Testing 1, 2, 3. Testing.
No. You just need to adjust.
I'm not in the right channel.
Yeah. There's a button. I think it looks like a little globe.
Yeah.
And you need to select the English channel.
Yeah, which I think I just did.
Okay. Est-ce que la traduction fonctionne?
Is the interpretation working now, Ms. Verschuren?
Merveilleux, pas de problème.
Wonderful, no worries whatsoever. Mr. Garon, please resume. Mr. Généreux said that I should speak in English, but in the bloc in Ottawa, we don't revert to English. We're not conservatives. I should point out. Now, Ms. Verschuren, if I could just speak very frankly here, I was a tad shocked by your opening remarks. In fact, very shocked. When one reads the Conflict of Interest Commissioner's report, when a normal, intelligent, smart person reads such a report, it can't be interpreted in any other way than as an indictment on you, on your management, on your poor judgment, and essentially it ends up eroding the public's confidence in the government's management of these kinds of programs and organisations. Now, when you said you accepted the report and its conclusions and findings, it's almost as if you're expecting to be congratulated that you were acting in good faith. Perhaps it's like you've latched onto the 3 positive lines in the report and stopped there. But there were 24 violations. Should you be being congratulated on the basis of that?
Je vais vous expliquer pourquoi je vous pose.
Now, let me explain why I'm asking this question. You've opened up a dialogue here by saying that you agreed to the findings of the report, and at the end of the day, this is a positive outcome, that you acted in good faith in all of this, and you don't seem to be inclined to accept any personal error on your part. Did you violate the Conflict of Interest Act on at least 4 occasions? I'm not talking about your intentions here. Evidently, your judgment is questionable. Did you violate the Conflict of Interest Act on at least 4 occasions?
Mr. Chair, I accept the findings of the Commissioner's report. Absolutely. And it was clear that in a number of cases, I abstained where I should have recused myself. Another situation with the COVID payments, I should have, I relied on legal advice that was not in the view of the Commissioner appropriate. And so those, I recognize that those things are, I certainly accept the fact that I should have done better or could have done better.
Dans son rapport,
well, the Commissioner in his report indicated that you decided to abstain from voting without recusing yourself, and that conduct was on the basis of an improper legal advice. How many years' experience do you have in this particular field in business administration?
I've been in business for a number of decades.
Et ça vous est arrivé souvent?
And has that occurred many times, that you've violated the core basic conflict of interest rules based on improper or erroneous legal advice? Is that a frequent occurrence, Ms. Verschuren?
Moi, je viens du ministère.
Now, in the business world, I'm from the academic world, but in your particular community, is this a kind of a regular occurrence, or is this a unique and singular occurrence?
Mr. Chair, this has not happened, to me in my past.
Donc,
so, despite all your vast years' experience, your wealth of experience, you decided to just abstain from voting. Here's a question for you, Ms. Verschuren. As a taxpayer and as a voter, a member of the public and a taxpayer, now there's a lot of taxpayers' dollars that funded SDTC. Now, what reassures me, despite the fact that you didn't vote, that you didn't try and influence the vote of others. On occasion, I've abstained from a vote in the House and yet participate in a debate. So how can I get any assurance that if I understood it after 3 years in politics, how is it that you couldn't wrap your head around that?
The Commissioner indicated that he did not see any areas of influence or, communication amongst the board in terms of
Monsieur le Président,
not
je me
recognizing.
permets de...
Mr. Chair, I'm sorry. I have to politely cut the witness off. I have just 1 minute remaining. The questions are important. Please don't see this as disrespect. Now, I understand that in terms of tangible proof that the Commissioner studied, this wasn't able to be demonstrated. So let me ask the question a different way. As a voter, as a citizen, as a taxpayer, we're talking about $300,000 that's funding the organisation, and it's an organisation like yours and its board. How can I have any confidence, a member of public, just like my voters would have confidence in me, that you didn't attempt to influence the decision making, despite the fact that in the minutes it demonstrates that you didn't vote? How can we get any assurance of that fact, that you didn't influence the vote of others?
Mr. Chair, I would never have influenced the vote of any other board member. It is how I operate myself. It's how I hold myself accountable.
OK. Merci, Monsieur Garon. Monsieur Massé, la parole est à vous pour 6 minutes.
Mr. Massé, 6 minutes.
Chair, and I'm trying to as well get an idea as to what took place in the boardroom there. Mr. Fischerin, you said that you've taken responsibility in the sense of accepting the Commissioner's report, and at the same time you repeat what the Commissioner said in the report on your answers, and I'm sure you can do that again, but you also said you were following the practices that predated my tenure. So please expand that. Is that the practice that was taking place, where the conflict of interest issues that you have taken responsibility for, is that learned behavior that you got at that board coming onto it?
Mr. Chair, I always took responsibility for, I declared the conflicts judiciously. And in some cases, I abstained where I should have recused myself and left the room. I did not know that was the case, and I took the advice of management and legal counsel here, and I followed what the practices were.
No, sorry, I didn't mean to. I won't let you finish. I wanted to follow up, but please go ahead. What practices you were saying?
So I followed the practices that management and legal counsel advised me in terms of how we were to deal with these conflicts of interest.
So can you explain the inconsistencies of your voting versus that of somebody else? Like at the boardroom, are you spending enough time together, you're familiar with each other in your own lives? And I understand from previous testimony that I asked, there was actually social behavior going on with the board. So I assume that you all knew each other fairly well enough. And you said that you're following practices that predated your tenure. So that means what information did you have about the previous board and their members and their voting practices? Where did you get that information for? Was that shared by other colleagues on the board, or was it something that was brought to your attention? Because clearly you're here for a reason, and clearly the Ethics Commissioner has a report that had its conclusion. But what's not clear is the overall practice on the board. And I think what some of the people like myself who are not privy to these private privileged positions have hard times understanding is basic rules when not applied, whether it's just you as an individual or whether it's the collective. And then what my concern is how far this reaches back, and you have already identified that predated your activity there.
Mr. Chair, when I joined the board of STDC, of course, I met with the Ethics Commissioner. I obviously disclosed all of the conflict that I had in the project that was approved in the previous year and a half. I continued. There was no indication that never saw a situation where board members talked about specific projects. There was governance. The project and review committee would meet after extraordinary amount of due diligence. That would be analyzed. The management would make a recommendation to the board. We declared conflicts. And, in the case of me, in terms of abstaining and recusing myself, I made a number of mistakes.
Learn that behavior from predated decisions, or is it you on your own? I mean, that's what you mentioned, that you followed practices that predated your tenure. So, it seems odd that you would be the only person doing this, and nobody would say anything, anywhere, any place, anytime. And it seems odd that you claim that you have a consistency with regards to your practices, but they went into the abyss on this particular matter. And it concerns me because the ethics commissioner was here saying that your model is actually a good model. That's what he said when he was here. So the bigger concern I have is the governance system in place in general across these boards and appointed positions and places of privilege. And then if you could just be really clear here, is this learned behavior that you got on SDTC because you mentioned that it predated you, or was it just this lapse at this point in time, and are you isolated alone by the only one that did this?
Mr. Chair, I followed the practices that were communicated to me in the transition as the chair of the board of SDTC. I was responsible for the governance of that organization, which included 4 committees. And that committee structure was critical, and amongst the board of directors that I worked with, I genuinely thought I was following all of the conflict of interest guidelines. The commissioner clearly indicated that I made 2 mistakes. The technical mistake of not recusing myself instead of abstaining, and listening to the advice of legal counsel that he felt was flawed.
Done. I'm going to go check myself for a concussion.
Okay. Thank you, Mr. Massey, Mr. Verschoen. Mr. Perkins, floor is yours.
Ms. Verschoen, the Commissioner's office just testified, just to be clear, that there are 24 conflicts of interest. You did, not 2. So, but I want to go back to my question on how you were appointed. You said that you didn't apply, that the Liberal Minister of Industry approached you and you had 2 conversations with him to do that. But we also have testimony here from the Liberal Minister of Industry, who said he was given a list from the Privy Council office, and that's who he contacted. And the Privy Council office, head of appointments, who was in place when you were appointed, said that she supplied 6 names to Minister Baines on that. And when asked if anyone had ever been appointed without being on that list, she said no, not that she was aware of. So, but you didn't apply, so I have no idea how you would have got on the list that Minister Baines then went and checked out. So who misled the committee? Minister Baines and the Prime Minister's Department, the PCO, on appointments, and saying that you applied, or you in saying you never applied?
Mr. Chair, I believe the situation was that there was indications that I was requested to consider to be an applicant to this. I'm sure that the Privy Council office would have would have looked at a number of applicants, I would expect.
Okay. Ma'am, let's move to a different question. In your opening statement, you said repeatedly that the Ethics Commissioner said you acted in good faith. So are those your words or his? Because I looked through his report. I read it before, and I trust you did too. It says good faith in there one time, but it's not in this report talking about you being found guilty of this corruption. But it's not, that good faith phrase isn't about you. So why would you make that up? Why would you assert that in your opening statement today? He didn't say you were acting in good faith.
Mr. Chair, we just heard from the Commissioner, and I accept his findings.
Okay. So, ma'am, if you accept his findings, you'll recognize that in his findings, he didn't say that you acted in good faith. How many Canadian tax dollars were given out in conflicts of interest by Liberal-appointed board members at Sustainable Development Technologies Canada? How much money? Just the number would be helpful.
The total amount of money?
Yeah, the Auditor General pegged the number at $330 million given out in conflicts of interest. Do you dispute that number?
The Auditor General stated that number. It's obvious that that is accurate.
So you agree? So, ma'am, are you proud of your time at Justin Trudeau's Green Slush Fund? It's a yes or no question.
The investments that STTC made into the clean tech industry has had an enormous impact on
proud?
Canada. I'm very proud of the work that STTC has done, yes.
Are you proud of the $300 million given out in conflicts of interest? Are you proud of the 24 instances of your own conflicts of interest? Are you proud that you used your position to help enrich yourself and your friends?
Again, I accept the Commissioner's findings. I recognize that there were two things that I could have been approved on in terms of that designation of recusing versus abstaining.
Okay, so I've got about 30 seconds left. I've got to say I'm not sure what's worse, that you didn't report the governance issues and demand change as chair of the board, or that it seems like you don't really think that you did anything wrong. So I have one question to finish my time. When will you return the money that you took from the Green Slush Fund?
Mr. Chair, I've been accountable, and people in public service in these positions need to be accountable. And I have been involved with 4 different reports. I have made myself available. None of these experts come to that conclusion. And again, the other major issue is that those investments were made in projects in Canada that really has grown the economy.
Okay, thank you. MP Van Bynen, the floor is yours for 5 minutes.
Mr. Chair, I keep hearing the words about being a Liberal insider. So, Mrs. Verschuren, you've donated extensively to the Conservative Party of Canada, and in fact, you consistently donated since 2013 to the Federal Party and also donated to 2 last leadership campaign. Can you confirm that you donated to the Rate Leadership Campaign back in 2017?
Yes, I have.
Can you confirm that you donated $1,675, close to the maximum allowable amount, to the Charest campaign on March 24th, 2022?
Yes, I have.
I see that this is the exact same amount that certain Mr. Perkins, and unless there's 2 of them, donated to the campaign. So that's a story for another time, I suppose. Mrs. Verschuren, is it true that you donated to the York Simcoe Conservative Association between 2013 and 2015?
York Simcoe. Is that Is that a liberal? Was that under
Simcoe
Christopher
Gray County
Freeland's?
Association, 2013, 2015. I believe that's conservative.
I don't recall, but
So conservatives then would have us believe that you're a liberal insider. That must totally explain why Prime Minister Mulroney, rest his soul, asked that you serve on his National Science and Technology Committee, and why Finance Minister Flaherty tapped you for his economic advisor to serve on his economic council during the 08 recession. How do you respond to these baseless comments made by the Conservative colleagues?
I've been privileged as a Canadian to work with many prime ministers. And as a citizen, I will work with the prime minister that is in power. I've worked with Prime Minister Stephen Harper. I have worked with other prime ministers, and I think it's really important for Canadians to be able to serve and give of themselves to help this country move forward.
Mrs. Verschuren, would it be correct to say that compared to other small and medium enterprise businesses, the clean tech sector and small innovators rely more heavily on the public sector funding to help de-risk these investments?
Mr. Chair, it's a really important point. These are high-risk, difficult projects to start. STDC begins the pipeline, and then other organizations, financial institutions support. Critical, important that we continue to invest in small and medium-sized companies. They are the future of Canada. And we are an innovative society, and those companies become large companies. Those companies export to other parts of the world. I am extraordinarily interested to move those organizations ahead, and I have been. And I think it's an underestimated area of potential development in our country.
This is a highly competitive, high-performing sector in Canada, and a few years ago, the industry accounted to between 2.9 and 3.3% of Canada's GDP. What does it represent today as a percentage of GDP?
I do not know that answer. Is it double?
I'm asking you.
I don't know. I don't know.
I'll pass on.
I apologize.
So it's important that we continue to invest in these industries, and it's important that the government continues to support these industries. But the issues and the concerns and the challenges that the industry has suffered throughout this issue has been a real challenge. You're not the only one to deserve blame here. I'll place some of the blame on the Tories that continue to malign the clean technology funding and continue to try to vilify a fund that is part of a wider ecosystem supporting a highly innovative, competitive industry in Canada. Canada is in the clean sector is a key driver of innovation in our country. Tories love to decry about productivity crisis in Canada, but yet they so brazenly malign some of our most competitive industries. But we know the Tories aren't solution-driven. They're jeopardizing the future of this entire industry, and I'll leave my comments at that. Thank you, Mr. Chair.
Thank you. Monsieur Garon, la parole est à vous pour 2 minutes 30.
Thank you, Mr. Chair. I'll take advantage of my turn to move the following motion. Given that the 6th report of the Auditor General, Sustainable Development and Technology Canada, has determined that the program failed in many respects when it came to funding, and that the projects were approved when there are in fact members of the board who are in the position of conflict of interest and they did not withdraw from the decision-making process, that the committee believes A, that the companies at fault acted in poor faith despite the ethics rules and the conflict of interest code. They have to reimburse the money they received from the program. B, that those companies that acted in good faith should not be penalised for the government's lax approach in the implementation of the SDTC program and its funding. Consequently, the committee proposes that the Auditor General write up a list of companies at fault that acted in poor faith in violation of the Conflict of Interest Code. Thank you very much.
Garon, est-ce que la motion a été
Has this motion been circulated in both official languages? Well, obviously everyone understands French, but we're working on that right now, and it's on its way, especially for Mr. Genero's benefit. Well, in the meantime, since the motion hasn't been distributed in both official languages but will be in short order, I propose that we suspend for a couple of minutes so all members can get the motion. Mr. Massey?
I was just hoping perhaps I could use my 2 minutes to get something that I would like done. It is separate to this, but I have limited time. But if I could do that, that would be appreciated.
Mr. Massin, I'm positive we'll have the time to get to you. I think it's probably best, given that there is a motion on the floor, that we deal with this one first.
Okay.
And then we come to you. But you're next on the list, so...
Okay.
Yep. So we'll briefly suspend just the time that the motion... Hey, Monsieur Garon, juste pour être sûr, vous présentez votre motion. Vous la...
Mr. Garon, you're moving your motion, right? Yes, and I apologise, but I'm not as au fait with procedure as some of my Conservative colleagues. But given that this is a topic at hand, we can debate it. Out of courtesy, I think that we can just suspend for a few minutes, indeed. Well, perhaps we could proceed with questions as it's in the meantime while it's being translated. How much time do you think it'll take to get translated?
Yeah, okay, we'll suspend for 5 minutes the time it's circulated, and then we'll deal with it. So, okay, yeah. Okay, meeting suspended for a couple minutes.
Là,
Merci. Monsieur Garon. Monsieur Garon, là, l'enjeu, c'est que vous ne pouvez pas déposer.
Mr. Garon, the issue is that you can't move a motion without having it in both official languages. Now, unfortunately, time's running short, and we have to stop at 6:30. The motion still hasn't been sent out in both official languages, so here's what I'm suggesting, if you agree. As soon as you get it in both official languages, it can be sent through to the clerk. Let me know, and then I'll hand you the floor and you can move the motion properly then. But in the meantime, how about we proceed with the witness who's in attendance today? Do you have any questions to ask of the witness, or should I hand the floor to Mr. Massey? Mr. Massey, the floor is yours.
Chair, and I want to make sure other colleagues get a chance to ask questions, and I do have something I needed to get on the record today on. I wanted to for business for this committee. I'm just going to read this into the record. For consideration for future business, that the Standing Committee on Industry and Technology undertake a study on the issue of credit card practices and regulations following recent concerns about the high interest rates, excessive fees, and consumer protection. This study should include, but not limited to, the following areas: A, interest rates and examining of the high impact of credit card interest rates on Canadian consumers and potential measures to cap or regulate these rates. B, fees and charges and analysis of various fees associated with credit cards, including the payment fees, annual fees, and foreign transaction fees, and how these fees affect consumer finances. C, consumer protections and a review of these measures related to credit cards, and with a focus on improving transparency in credit card terms, interest rates, and fees. D, predatory lending practices that investigate into predatory lending practices within the credit card industry and recommendations for stricter regulation to prevent exploitation of consumers. E, financial literacy with consideration of the role of financial literacy in helping consumers manage credit card debt and potential initiatives to enhance financial education. F, regulatory oversight, including an assessment of the effectiveness of existing regulatory frameworks overseeing credit card companies and potential impacts to ensure fair and transparent practices. The study should be comprised of no fewer than 4 meetings and include consultations with relevant stakeholders, including financial experts, consumers advocacy groups, and representatives from the credit card industry. I just want to table notice of it for now, and I'll turn my time now over to other members of the committee, and thank you, Mr. Chair.
Thank you, Mr. Massey, for this notice of motion. I am just informed by colleagues that I would have needed unanimous consent to withdraw the motion, or you would have, Monsieur Garon, vous auriez eu besoin du consentement unanime.
Mr. Garon, you would have needed unanimous consent to withdraw your motion and then resubmit it when it's translated. Now, I take it for granted that I do have unanimous consent, but I just want to make sure I'm doing things properly. Do we have unanimous consent for the withdrawal of the motion, and it'll be resubmitted at the end of the meeting, or by the end of the meeting? No one seems to have any problem with that. Mr. Généreux, the floor is yours. Now, Ms. Verschoen, the Commissioner determined that you were guilty when it came on 24 occasions, in fact. Now, if I benefited from the money invested by others, I would know right off the bat that I was doing something that was improper. How is it that with all of your vast experience that you were not aware that you were acting improperly? Now, you stated earlier that you spoke to the Ethics Commissioner before your companies received that money. Why did you actually accept the position in the first place then?
Mr. Chair, in terms of your question on recognizing that there were conflicts, I established that this was something that I could contribute to in terms of being the chair of STTC. I had an interest to promote this clean tech sector, and of the 24 conflicts, 20 of them was the fact that I abstained as opposed to left the room. I want to make it very clear.
I'm sorry to cut you off, but listen, I was a mayor of a city, La Côtière, and I'm an entrepreneur and I was a provider to the city before I ran to be mayor, and I knew that when I became mayor, I'd no longer have access to contracts or money from the municipality. They are core governance rules at play there. So how is it that on 24 occasions you didn't have that knee-jerk reaction, i.e. that that you should not only not be at the meeting, but you should recuse yourself and not be actually in the meeting room? Honestly, it's a bit hard to fathom. How is it that you didn't realise, given your wealth of experience, that you didn't think that through and say to yourself, I absolutely must not be here. I cannot take any decision that might benefit my company. How is it that that never crossed your mind?
Mr. Chair, it certainly crossed my mind and that's why I declared when there was a perceived conflict, and these are all perceived conflicts that we're talking about here. So it was really important for me to recognize that, and I felt I followed the procedures that I thought were correct.
Sorry to cut you off, but I said to you earlier that you had a counsel who gave you advice to ensure that you wouldn't be in a position of conflict of interest. And apparently it's that legal counsel's fault, or those lawyers, I don't know if there are a number of them, but it was their fault because they misled you. But let me repeat what I said earlier. Now, I know what it means to be in a position like you. You're a smart woman, Ms. Verschuren. How is it possible that it didn't cross your mind? You didn't realise I've been on a number of boards, including the Port of Quebec City, where I was also a provider prior to that, or a supplier rather. And I completely stepped aside when I sat on the board because I knew I no longer was entitled to those contracts. So how is it? I can't fathom how you didn't realise that you had no business being there.
Mr. Chair, when I got on the board of STDC, I clearly disclosed to the minister, to the ISED people, to management, that I had a declaration that happened 18 months prior to me getting on that board. That is the only real conflict that I've had over the whole term of my chairmanship.
Ms. Verschuren, I have some questions, particularly about NR Store, which you are the founder and still owner and chair of the board of, I believe. You've been involved in projects, in particular with NR Store and Hydro Store and Oneida. That project received last year, I believe, $50 million from Canada's Natural Resources Department. Is that correct?
That's correct.
And that project received $170 million from Canada's Infrastructure Bank?
That is correct.
And Andre Lise Matot, the director who served on the board with you, Cycle Capital, but served on the board with you at the Green Slush Fund, she was moved over and appointed by the Liberals to the Infrastructure Bank when that money was finally approved. Is that correct?
That is correct.
You're the chair of MARS in Toronto, which I believe gets about a third of its financing from the industry department. Is that correct?
Yeah, MARS is a non-for-profit organization that does receive money from the federal government and provincial government.
It's about a third of your budget. Has MARS, and you chair that, has MARS given NR Store and its project with Oneida Hydro Star any money, taxpayer money?
that I do not believe that Mars gave Enerstor and Hydrostor any taxpayer money.
So you have not benefited, the companies that you own have not received any money whatsoever from, or the ones that are associated with the projects like Oneida have not received any money from Mars, which is funded a third by the federal government.
That's correct.
Okay. So if I've got the number correctly, that's you got 170 million from the Infrastructure Bank, 50 million from Natural Resources Canada. That's a lot of money. Outside of that, it appears to be very profitable to be connected with these Liberals and be on the SDTC board and to do their bidding so that other Liberals can get money. And then in return, in other government organizations, your projects got money. It's a lot of taxpayer money.
I'm not sure there was a question there, Mr. Perkins, but that's all the time you had. Thank you. Mr. Turnbull, floor is yours.
Thank you, Chair. So, Ms. Verschuren, thanks for being here today. So you have said multiple times that you followed correct procedures, and you've also said you accept the Ethics Commissioner's report and the Auditor General's report and findings, and that you, in fact, abstained from votes where you should have recused yourself. Do you regret not having recused yourself?
Mr. Chair, yes, if to do it over again, I would have absolutely recused myself. I just was not aware that the difference between abstaining and recusing.
Can I now ask you, you have been appointed, I have a list here of quite a number of appointments that you've had over the years, going all the way back to 1987, where you were appointed by Brian Mulrooney to the National Advisory Board on Science and Technology. When you were on that National Advisory Board, did you declare conflicts of interest, and did you abstain versus recuse yourself in situations during those regular board practices?
Mr. Chair, that advisory board was chaired by the Prime Minister. And the objective of that board was to work with the Americans' counterparts, an equivalent number of people, to bring and develop science and technology in both of our countries. So there weren't decisions made, other than advice being given to both governments.
So I get that. So there were no funding decisions made. But so you didn't have to abstain or recuse yourself from anything because there was no votes taken, is that right?
That's correct.
Okay. And then what about when Stephen Harper appointed you to the North American Competitiveness Council? So I know that was another appointment you received. Did you, in the regular practices of that council, have to abstain or recuse yourself in any situations? And did you declare conflicts of interest, perceived or real, that occurred in any of the council's undertakings?
Mr. Chair, bit of a similar circumstance with the Prime Minister, Stephen Harper. He asked me and a number of other Canadian leaders to join him in Mexico and work with him to open trade barriers between our three countries.
Okay, great. And I note that you were appointed by Jim Flaherty to the Economic Advisory Council, appointed by Jim Flaherty again to the Venture Capital Expert Panel, and then again by Jim Flaherty in, this is 2014, the Venture Capital Expert Panel. So I assume all of those were panels and advisory and were not making funding decisions. Is that correct?
That's correct.
Okay. So, were you ever accused of being a conservative insider for your appointments and your service on any of those advisory panels or councils?
No.
Okay, and I know that my colleague had already mentioned that you have donated quite a number of times to the Conservative Party. So what I'm taking issue with, like, I think you have, at least to some degree, taken, you know, you've owned up to the mistakes you've made and expressed, you know, that you regret that you didn't recuse yourself when you should have. I mean, I would say you ought to have known. I believe you ought to have known that you should have recused yourself because that's in the conflict of interest code that you were supposed to abide by. So in essence, you are responsible as the board chair, and I think you've expressed some regret. But what I take issue with is the Conservatives calling you a liberal insider, which I don't believe is the truth. I believe that you've shown yourself to donate to the Conservative Party and have been appointed for many, many years and served under quite a number of Conservative leaders in this country. So, but what I wanted to ask you is that you donated $1,675 to the Jean Charest leadership campaign, as did Mr. Perkins on this committee. And I wanted to ask you whether you thought you were as much a conservative as Mr. Perkins and or as liberal as him.
Mr. Chair, I've never been associated with any party. The public offices that I've held and the responsibility that I held during my career really, I made the decision never to be associated with a party, and so I leave it at that.
Thank you. Merci. Je retournerai à Monsieur Garon.
Mr. Garon, we've received the motion. It's been translated, and it's been translated in both official languages. So I imagine that members have had an opportunity to read the motion. I don't know if you have any other comments to make, Mr. Garon, at this point, or we can move to debate. It's been sent out, so the motion's on the floor. Well, if I may indeed take the floor, you can comment briefly. I know that time's running out, and I know everyone's received the written version, and my apologies for the procedural issues. Next time, I'll make a better effort at sending it out in both official languages, and I apologize. Basically, this motion calls on the Auditor General to provide a list of companies that received money from SDTC in violation of the Act and ethics rules. It's a motion that contains, that has similar content, was approved by the Committee on Public Accounts, but it's important that the INDU committee adopt the same motion, given that the industry minister is particularly implicated here. And there's an additional element, and I'll finish on this because it's important to note. Given everything that has occurred in relation to SDTC, we need to remind ourselves that the green transition is important. We need government investments in the green transition. It's for the public good. And I've often said to witnesses who've appeared before us that very same comment. Now, it's a tragedy, a travesty what's occurred at SDTC, and has undermined significantly the public's trust when it comes to the use of taxpayers' dollars. And the fact of the matter is that companies' funding has had to be frozen, companies that had positive spin-offs for our communities, and especially in the context of a green transition. And some companies will have to pay money back based on objective criteria, and it's quite in order that the Auditor General provides such a list. Moreover, it should be stressed that there are some companies that are not at all to blame and that they should be protected in any such process. Thank you, Mr. Garon. Debate. Mr. Massey, and then Mr. Turnbull.
Thank you, Mr. Chair, and I thank my colleague for bringing forth this motion, and no need to apologize. This has been very much a long, difficult issue we've been dealing with, and now other committees in Parliament have been dealing with it. So I actually do appreciate the motion because he is correct. Unfortunately, part of the victimization of this has been a couple things that I still want to see concluded. That is to have the full restoration of the compensation for employees and whistleblowers, and also their confidentiality agreements and non-disclosures that they were forced into, torn up at some point in time, and we're just looking for the appropriate vehicle to be able to do that. This motion, it wouldn't be appropriate because it deals specifically with the Auditor General, which I think it as well is very responsible motion, because using that third party being the Auditor General, not the committee or Parliament going line by line through the different types of businesses, is important, because we want that objective to be independent, and I think a lot of parliamentarians and Canadians have full confidence in the Auditor General process. So I think that the movers' use of the Auditor General in this is actually very wise. And I'll just conclude with this as well too, is that we do not want to lose the opportunity for the good companies to be able to get the appropriate supports that they deserve for greening the economy, but also to a new innovation that's necessary, and then weed out the ones that didn't really receive these things responsibly, so they can return that to better investment. So with that, we will be supporting as New Democrats this motion, and thank the mover for it. It's straightforward, it's simple, and it separates the objective of Parliament in terms of looking for accountability with the practical elements of having the Auditor General as a third party to be able to decipher exactly how to go about the next stage, and I think that's a very wise way of approaching it.
Thank you, MP Massé. MP Turnbull.
So as I read this, I have a number of issues that come up for me with regards to this motion. One is that the committee declares, and I'm quoting from it, and then I'll tell you what I think, that it is of the opinion that the offending companies, first of all, I'm not sure, did the companies actually offend, or was it the board members that offended? They're the ones that are said to have contravened the code of conduct. It's not necessarily the companies. There's many companies that may be in the portfolio that SDTC funded, which were completely, could be anyway, from my perspective, that the funding was merited and that the due diligence was done. That's, you know, I think we've read in previous reports, I remember reading quite a lot of extensive information in numerous reports about how much due diligence was done at the organizational level within the organization for the board to eventually approve funding decisions. So, and then who are we asking to make the determination of who acted in bad faith versus who acted in good faith? So how are we to know that? So we're asking the Auditor General to do that work. We're asking them to determine. So they've already done, the Auditor General's already done an investigation and hasn't been able to determine that. They've determined that there were conflicts of interest perceived, and the Commissioner, I'm using his words, said a technical violation. So we could disagree about that. Maybe some people feel that there was more than a technical violation. I agree that Ms. Fisherin and some of the other board members ought to have known that they should have recused themselves, that it was their responsibility to be aware of what's in the conflict of interest code, 100%. So, but they've also all lost their positions. Is that sufficient? I don't know whether you guys feel like that's sufficient. But when I look at this, like, who is going to determine who acted in bad faith? So we're now saying that the Auditor General's got to do an investigation of every single company to determine who's acted in bad faith. I'm not sure that the Auditor General would be able to make that determination. I'm not sure what you guys think, but that seems to me to be asking a lot of the Auditor General. And then you're asking them to report who acted in bad faith and then retract funds, right? That's what the gist of this motion includes. So I'm not sure whether the Auditor General, that's making a lot of demands on the Auditor General, who's supposed to operate independently. Like, we're not supposed to be giving direction to the RCMP. We're not supposed to be giving direction to the Ethics Commissioner. We can lodge complaints and they investigate if they see fit to do so. The RCMP, the Auditor General, the Ethics Commissioner are independent officers that are supposed to do their work independently of us. So we're now telling the Auditor General that they've got to do a determination that I think is us overstepping our role. in Parliament. So convince me otherwise. But the other thing that I would take issue with is it says the laxity of government's laxity in implementing the SDTC program. I take issue with that, Mr. Guérin. I don't believe that there is laxity on behalf of this government at all. The SDTC is an arm's length organization. It's independent. It's been operating for many, many years. And so to what degree is the government of the day responsible for oversight of that? Well, you and I will argue about that then for the rest of the meeting. So let's go. Fine. Let's argue about it for 10 meetings. I don't care. But, like, I don't agree. I don't agree. And I'll make arguments to the contrary of what you're going to say. So I don't believe that the government has been lax on SDTC at all. And so I will defend that. Thank you.
Thank you, Mr. Turnbull. I have Mr. Garon, but I'll just volunteer one small comment. If I read the motion correctly, it says it proposes that the Auditor General and the committee is of the opinion. So it's not very much binding as a motion from my reading of it, though, in terms of the added burden on just my 2 cents on this. Monsieur Garon.
Attendre, Monsieur Turnbull. Well, now, Mr. Turnbull would not normally filibuster in this manner. It's listen, all jokes aside, here's what I'd have to say. The committee, Parliament, has no business telling the Auditor General what to do. We know that full well. And it's in that spirit that the motion itself was drafted. We're suggesting that the Auditor General provide a list. Is she obligated to comply with the motion? The answer is no, but she will know that there is a willingness on the part of the government and the committee to learn more about and dig deeper into this situation. Now, it's difficult to draft this kind of motion. Well, in fact, I guess this when I drafted this motion, it was with a view to seek a consensus. Now, Mr. Turnbull made a few comments initially. The Public Accounts Committee moved in a motion. It was adopted unanimously, unless I'm mistaken, ordering that certain amounts of money mandatorily would be reimbursed within a 100-day time frame. And there's a presumption inherent in that some companies would have received these monies. And this is a presumption that the Liberals and the New Democrats seem to be in agreement with, as well as the Conservatives, I'm not mistaken. Now, I listened to the Commissioner's testimony earlier, who mentioned that Minister Baines at the time had certain tools at his disposal in order to prevent this kind of situation, that those tools existed. Did the minister have that information? Well, that's to be verified. But that said, nothing in this motion binds the Auditor General in any way whatsoever, and nothing in this motion, in fact, denounces the government ahead of right out of the gates. It's, as I said, non-binding on the Auditor General, and if it turns out that Mr. Turnbull's right and that the government was engaged in a due process in terms of the operations of SDDC, well, I don't see why the party in power would be reluctant in any way whatsoever to support this kind of motion. You know, if you have nothing to hide, well, you open your books up and you show everyone. Thanks, Mr. Chairman.
Merci, Monsieur Garon.
Thank you, Mr. Garon. Mr. Turnbull.
Yeah, I mean, I would argue that we've done that from day one. I have a list here of a page and a half of all of the interventions and the work that our government has done to get to the bottom and expose all the facts in this particular case, all the collaboration that we've had with independent officers. So there's nothing to hide at all. But the point in there that says government's laxity in implementing the STTC program is something that, to me, you know, I can't, in good faith, support a motion that includes the, essentially, I would have to agree with that statement, and I don't agree with that. I don't believe that the government has been lax. I believe that as soon as we found out about allegations of mismanagement and misconduct, we acted. And I stand by that. And if I believed otherwise, I would say so, And so I really do believe that we acted quickly and we're forthcoming in terms of collaborating with all of the independent experts and groups. So if you take that out, I think maybe we could get it or we could support it. Again, the fact that it's proposed to the Auditor General, I think, is noteworthy and it makes me feel a little bit more comfortable. Thanks.
Monsieur Massé.
Want to just get results at the end of the day for this, and so I'm prepared to move the motion to remove that component. If a Liberal isn't willing to do it, then I'll do it because I want to see us get this through and get some results.
Okay, so Mr. Massé, can you just clarify or what the motion would be?
Well, unless, Mr. Turnbull, you want to propose, why don't you propose what you're concerned
So
about?
just thinking on the spot here, everything, so it says it believes that companies that acted in good faith should not be penalized, semicolon, and cut out for the government's laxity in implementing the SDTC program and allocating funding. If you want to take that clause out, I think we can probably support it. Pardon?
Okay, so we've heard Mr. Turnbull's proposed amendment. I'm not sure if it's Mr. Massé or Mr. Turnbull's proposed amendment, but let's say Mr. Turnbull for clarity's sake. Is there a consensus around the table, or should we put it to a vote? Vote, okay. So you've all heard what's being proposed by Mr. Turnbull, the amendment to the motion. So, Madame la Greffière.
Mr. Gahir.
In favor?
Mr. Aria.
Yes.
Mr. Turnbull.
Yes.
Madame Jones. Mr. Van Bynen. Yes. Mr. Perkins.
No.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Barrett. Monsieur Garon. Mr. Massey.
Okay, so the amendment is passed, which brings us back to the motion as amended. On arrive à la motion telle qu'amendée.
The motion as amended. Any other comments on the amended motion? If not, let's vote on the amended motion, Madam Clerk.
Mr. Aria.
Yes.
Mr. Turnbull.
Yes.
Ms. Jones.
Yes.
Mr. Van Bynen.
Yes.
Mr. Perkins.
Yes.
Mr. Brock.
Yes.
Mr. Cooper.
Yes.
Mr. Barrett. Monsieur Garon.
En faveur.
Mr. Massey.
Merveilleux, à l'unanimité.
Wonderful. Unanimous. What a wonderful demonstration of a consensus. The meeting has come to an end. It's 6:25 p.m., so I'll just close this meeting. And we'll see each other again on Thursday morning. See the study on C27.
It's not entirely, I would have to split it amongst four, so for a minute, I don't think it's that worth it, Mr. Perkins. So on that note, colleagues, the meeting is adjourned. See you on Thursday.